Good morning, Mr. Chapman.
Good morning, Your Honor.
You can proceed when you're ready.
Thank you. Before the court is Angel Sager. Ms. Sager is here today after failing to appear before this court on February 21st of 2024. Bond is currently set at $603. This is the third bench warrant. She reports no employment. Last payment made on this account, and only payment made on this account, was a $50 bond forfeiture. That was in September of 2023. Front of the court recommends that a reasonable bond be set on this matter and it be scheduled for hearing on March 27th, 2024 at 8:00 a.m. before this court.
Ms. Sagers, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your attendance at the next hearing on March 27, 2024 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, ma'am?
No, sir.
Okay. Well, court does note that it is your third bench warrant, and court will note as well that you've never made a voluntary payment other than the bond forfeiture. So the court is taking that into consideration. And as a result, I am going to reduce your bond in hopes that you could be released pending that hearing. I'm going to set your bond in the amount of $300. If you're able to post that, you'd be able to be released. Do you have any questions?
No, sir.
Okay, thank you. We'll see you back on the 27th, and you have a good day.
Via telephone.
You too.
Good morning to both of you.
Good morning, sir.
Court notes that we were back in court previously on February 5, 2024. Court will note that the appropriate paperwork was submitted, but there was a front of the court objection on March 12, 2024. I'll ask Ms. Brown, have you addressed that objection and resubmitted the paperwork to the front of the court?
Good morning. Yes, I have.
Okay, thank you. What happens is, unfortunately, they're behind, so it's taking a little bit of time to see if again on the second approval, because they are so backed up. But what we'll do is, being that it was a limited, ma'am, how many objections did they have? Do you recall?
The last one was just on one form.
Okay.
Yes, ma'am.
What we'll do is we'll check with them. If it was submitted on the 12th, well, that's when they objected. When did you resubmit that?
That's when they objected. The last submission was on Monday, this Monday, the 18th. The last
Okay.
submission.
We'll give them probably about a week, and then we'll try to track it down, see if we can't get them to move that up and see if, again, the objection's addressed. If they do, then we can maybe expedite this, but we will track it down and hopefully get the approval. And if we get the approval, then we'll be able to enter the judgment at that time. So
Okay.
I'm not going to reset this for another hearing, because if they approve it, then there won't be any need for that, and I don't want to drag you both back when you may not need to be here.
Okay.
Okay.
I have one question.
Sure.
Judge Krouse. When they approve it, will I get notified? Well, when we get the response, hoping it's approval, will we get notified by the FOC representatives?
Yes, yeah. They'll send you, just like they send you an objection form, they'll send you an approval form saying it's approved. And then once they approve it, within a day or so, we'll have it entered at that time.
Okay.
Okay?
After that, is there anything else that I need to do?
Nope, nothing else that you need to do at this point.
Okay.
Okay?
Okay.
Mr. Brown, do you have any questions?
Yeah, just so I'm clear. So once it's approved, the notification will be sent to Cheryl that it's approved. And then you said it'll be entered into the system within a day or so. So
Yep.
then it'll just be a letter in the mail telling me that this is complete?
Well, what's going to happen is because she'll get back her copies of the judgment and all that, and then she'll have to serve you with a copy of the final paperwork, because she is the plaintiff, and so she'll have to send you copies of everything.
Okay.
Okay?
Okay. Yes, sir. Thank you.
And then once you get those and you see that my signature's on, then the divorce is complete. At that point, you are divorced.
Okay.
Okay? Okay, thank you both, and you're free to go. Have a good day, and hopefully we can get this expedited.
All right. Thank you, sir. Appreciate it.
Thanks.
Thank
All
you.
right, thank you. Let's move on here.
Is this Lindsay McKediac on the 0223?
Yes.
Okay, we'll just have you here via
Good
telephone.
morning to both of you.
Good morning.
What it is, this is a scheduling conference and the court will put in place various dates as well as various processes so that the case proceeds in an orderly fashion. I will go to the plaintiff first, then I will go to defendant, and we'll kind of go that way as we go through. And at the time that this is done, then you will get a case scheduling order, which will set forth everything that we're talking about today. I'll ask you, Mr. McKediac, what issues do you believe to be in dispute in this case?
I mean, as far as,
Well,
like, I want-
custody, support, parenting time,
Yeah, I
property
mean-
division, spousal support, or other.
yeah, I don't really want anything but the judge to redo the visitation so I can see my son. I pay my child support, all the money I've invested into the relationship or our house or whatever. I don't want a part of the house. I just want to be able to see my son
Okay,
without her controlling the matter.
okay. So I'll put down, based on what you said, Mr. McKediac, that parenting time is the only issue that you believe to be in dispute.
Correct.
Okay. Ms. McKediac, what issues do you believe to be in dispute?
He has financially abused me.
He has
my
what?
whole- Financially abused me throughout
Okay.
the whole marriage.
Okay, I've never heard that. How would that happen?
Destroyed all mine and my child's stuff, selling all my stuff, making it so I only have $12 to my name.
Okay.
Taking my
So
money.
with that, ma'am, what do you believe to be the disputes then? Is there property division? Is there spousal support dispute?
Yes,
Okay. I will put that down.
and to protect my child from being anywhere near him.
Okay. There is a process whereby you can get information from the other side, and that's called discovery, where you can serve the other party with interrogatories, requests for production of documents. You can have depositions, etc. Mr. McKediac, are you anticipating any discovery?
I mean, no, she doesn't. I don't see her hiring a lawyer. If she ends up getting a lawyer and dragging it out, then I'll retain counsel myself. And then we can go the rougher route. You know, she's trying to replace material that was already replaced when I redid the house.
Okay. What I'm going to do, because the case is early on, I'm going to give you until June 1 to do discovery. Okay, so that means anything that you have that you want to get from the other side as far as information, you have to do that before June 1. I'm not going to, again, extend that because you have enough time to do it. So make sure it gets done before that time.
Okay.
What I'll do is that will put June as the mediation month where you will meet with an attorney mediator. There is a cost associated with that because they don't work for free. And I'll ask you, Mr. McKediac, do you have anybody you recommend as a mediator in this case?
No, I don't yet.
Okay. Ms. McKediac, do you have a recommended attorney mediator?
And do I have an attorney?
No. Do you have someone that you recommend or that you'd like as a mediator?
What, I don't understand, I guess, what that means.
Okay. What'll happen is, being that the two of you have not designated a mediator, the mediation clerk will randomly assign an individual to serve as the mediator.
A mediator for what, though?
Excuse me?
A mediator for what? I guess I'm.
Well, you said that there are issues of property and spousal support, and Mr. McKediac said child or parenting time. So what happens is the mediator will meet with you and attempt to come to a resolution of the case after having met with you.
Okay.
And then at that point, if there is a resolution, the mediator will take that and, record or prepare it and have it signed, et cetera. And then that will conclude, if you resolve all the issues, then that concludes the case other than the final paperwork. If not, then, again, we have to do some more.
Okay.
What's going to happen is we're going to be sending out this case scheduling order. I will tell you both, pay attention to what's in the case scheduling order because there are various dates in that order. And if you don't comply with those dates, it could have an adverse effect upon your case. For instance, there's dates in there as to when you have to exchange exhibits. There's dates in there in which you have to exchange a witness list, et cetera, that you have to exchange a property division chart. And if you don't do that, again, that could jeopardize your case as we go forward. So make sure that you pay attention to that when you get that and do what you need to do. Okay?
Yes.
Mr. McKediak, do you have any questions?
No, sir.
Okay. Ms. McKediak, do you have any questions?
Not at the moment. No.
Okay. You'll get this order sometime probably the end of the week. And as I state, make sure that you pay attention to that and that you comply with all of the dates in there, just so that you don't impede your case or create any problems as we go forward. So that will be the order.
Date for the settlement conference.
Oh, yeah. I have set the settlement conference in this matter for July 8, 2024 at 1:30 p.m. If you don't settle at mediation, you will have to be present at that settlement conference. Well, you have to be present at the settlement conference in any event, but we may be able to get taken care of before that if we do have resolution at settlement. I mean, at the mediation. Okay, thank you. That'll go out in the mail.
July 8th at what time?
Excuse me?
July 8th at what time, sir?
The time of the July 8th.
Oh, it's 1:30 on July 8th.
And what is that date?
July 8th.
Yes, what is that for?
That's a settlement conference, so that
Settlement. Okay.
Yeah, and that date's it's in the order, so you'll be able to see it in there.
Okay.
Okay, thank you. You're free to go. Have a good day.
You too. Thank you, sir.
Motion for admission to practice law in the state of Michigan.
Again, good morning.
Morning, Judge.
Mr. Brundage, I will tell you that your sister's upstaged you because she was here bright and early and waiting for you.
I just wanted to make her nervous, see whether I'd show up.
Okay.
That sounds like you.
Yeah, that's good. I guess at this point, you've got the time, you've got the leverage, so, you got to utilize that, don't you?
For now, yeah.
Okay. I'm sure she'll get even with you and come up with something that, where she'll be able to get back.
No, this might be payback for all the childhood abuse we've heaped on
That's
him.
right. She's older than me, Judge. I've got a lot to pay her back for.
Yeah, that always happens with the older sisters, doesn't it?
Yep.
Okay. Well, again, we're here before the court for the motion for admission of Barbara Ellen Brundage to the practice of law in the state of Michigan. Mr. Brundage, is there anything you'd like to say or that before we proceed?
No, Your Honor, except that I appreciate you taking the time out of your schedule to do this for us. And I think I'll go forward with my motion to ask the court to admit her.
Okay. I have nothing special other than I thought that before this, as I had an opportunity to practice before your father on the probate bench, I thought about coming up with a story that I might be able to relate. And unfortunately, I found that I probably couldn't repeat most of them on YouTube. So I thought it's best just to be quiet, maybe.
Not
That sounds
surprising,
about right.
Judge.
Yep, yeah, I second that. That's not surprising at all.
Okay. But I thoroughly enjoyed practicing before him. And one thing I always enjoyed that he always made everybody feel at ease and relaxed, notwithstanding what was happening in the case. He always handled his courtroom very appropriately in a professional fashion. And so I always enjoyed that because I practiced most before him when I was a new attorney and probably didn't know anything. And he always was very helpful in that getting us through the process. So
Yeah.
court will note that in this matter, we do have a letter from the executive director of the Board of Law Examiners, Maribeth Graff, stating that the petitioner in this matter has complied with all the statutes in this particular matter and is appropriate for admission to the bar of Michigan. So at this point, Ms. Brundage, all I have to do is swear you in. And I'm not going to ask you to repeat after me because it's pretty lengthy, but I will ask you at the end for affirmation in this matter. And state, if you would, if you raise your right hand, do you solemnly swear or affirm that you will support the Constitution of the United States and the Constitution of the State of Michigan and maintain the respect due to the courts of justice and of judicial officers, that you will not counsel or maintain any suit or proceedings which shall appear to be unjust, nor any defense except such as you believe to be honestly debatable under the law of the land, that you will employ for the purposes of maintaining the causes confided in you such means only as are consistent with truth and honor, and will never seek to mislead the judge or jury by any artifice or false statement of fact or law, that you will maintain the confidence and preserve inviolate the secrets of your clients, and will accept no compensation in connection with your client's business except with your client's knowledge and approval, that you will abstain from any offensive personality and advance no fact prejudicial to the honor and reputation of a party or witness unless required by the justice of the cause which you are charged, that you will never reject from any consideration personal to you the cause of the defenseless or oppressed or delay any cause for lucre or malice, that you will in all respects conduct yourself personally and professionally in conformity with the high standards of conduct imposed upon members of the bar as conditions for the privilege to practice law in the state of Michigan. You can say,
Yes, I do.
thank you. Well, that's all that we have to do, and I will sign the order in this matter, stating that you have been sworn in. Then you're going to have a form that you'll have to sign before the clerk, and then they will prepare the final paperwork for you.
Very good.
Okay.
That was my.
Mr. Brundage, anything else for you?
Nothing more. Thanks again, Judge. Appreciate it.
And Ms. Brundage, it's my understanding that you're doing this because you wanted to pursue some pro bono work and do something of that nature.
That's right. This is a pre-retirement planning. I'm work for the federal court as a judicial clerk in the Southern District of Illinois currently, and so my that limits my ability to do outside practice at this point, other than like pro bono stuff for family. So it's more after I leave that job, but there may be a few opportunities currently.
Okay. Well, it's admirable that you are going to do some of that because there's obviously a substantial need and a substantial amount of individuals that are needful of that particular service. So you're to be commended for that. And we will conclude with this and say you're free to go. Have a wonderful day.
Thank you so much, Your Honor. Thank you for your.
Who do we have before us, Ms. Brown?
Alexandria Krouse. She has 3 dockets.
Okay. Ms. Krouse, in this matter, you're before the court charged with civil contempt of court as a result of your failure to pay child support and related expenses. Upon a first violation, you could be held in contempt of court for up to 45 days. If it's a second or subsequent offense, up to 90 days in jail. Do you understand that?
Yes, sir.
Court has appointed Ms. Huffman to represent you in this matter. Have you had sufficient opportunity to speak to Ms. Huffman in preparation for this proceeding?
Yes, I have, sir.
Okay. And Ms. Huffman, are you ready to proceed?
I am. Thank you, Your Honor. Ms. Krouse is before the court today for a bench warrant hearing on 3 dockets. Docket 2008, or docket 2009, and docket 2017. Ms. Krouse failed to appear at a hearing before Your Honor in January of this year. On the 2008 docket, Ms. Krouse has a monthly obligation of $72.50. Her last payment was March 2nd of 2023. That was through an income withholding with unemployment. This is her 9th bench warrant hearing on the 2008 case. She has a total shortfall of $858.25 and a total arrears of $2,279.78. On the 2009 case, Ms. Krouse has a monthly obligation of $143.50. Her last payment was March 2nd of 2023. That was $43.23 through that income withholding. This is the 7th bench warrant on the 09 case. Her total shortfall is $1,626.34. The total arrears are $8,022.79. On the 2017 case, Ms. Krouse has a monthly obligation of $169.50. Again, her last payment was March 2nd of 23. That was $55.71. This is the 5th bench warrant on the 17 case. Her shortfall is $1,910.73. Total arrears are $7,554.60. Further, the court would like the court to be aware that Ms. Krouse booked into the Calhoun County Jail on February 29th. She was sentenced to serve 90 days back in December of 2019.
Okay. Ms. Huffman, do you dispute or contest any statements made by Ms. Brown?
I do not.
Do you have any questions for Ms. Brown?
Yeah, I would just ask a couple things. First of all, on each case, you indicated a monthly obligation, but that includes the arrearages. Is that correct?
Correct.
And there's a $50 arrearage on each of those cases?
Yes.
Is that typical to put a $50 arrearage on all individual cases?
So each case is set individually, let me say that. We have a guideline amount, but this $50 amount for Ms. Krouse was actually judicially set back in 2015.
Okay, thank you.
You're welcome.
Any proofs, Ms. Huffman?
Yeah, I would call Alexandria Krouse, please.
Okay, go ahead.
Andrea, can you hear me okay?
Yeah, I can hear you.
Okay, thank you. So I'm just going to ask you questions regarding it's going to be standard questions regarding all 3 of the cases, okay?
Okay.
All right. Are you currently working anywhere?
I take care of an elderly couple, but I'm paid under the table as of right now. And I had employment, but due to being in here, have lost that opportunity and probably several others.
Okay. So regarding the individuals that you take care of and get paid under the table, how much do you get paid on those?
$14 an hour.
And how many hours do you work a week?
Over 40.
And do you pay any of your child support obligations with that money?
I haven't yet. I plan to start.
Okay. How long?
I was gonna say I just started taking care of them probably about a month ago.
And how long do you expect to be doing that job?
Until they pass away, unfortunately.
Okay. Are they relatives of yours?
It's an ex's grandparents.
Okay. So you've been looking for other more stable employment, is that correct?
Yeah.
Okay. And where have you been looking?
Indeed is my main source for that.
Did you say Indeed?
Yeah.
Okay. And have you put applications in a resume?
Yes.
Okay. How many do you say you put in a week or a month? How often do you put?
I probably put at least 10 in a week.
Okay. And did you have an interview recently or no?
I've had interviews lined up that I've missed due to being in here.
Okay, so it says that your last payment was in 2023, March of 2023. Why haven't you made a payment since then?
I haven't been employed, and honestly, I have a past of drug use, and I haven't been clean up until just this past year.
Okay, so how long have you been, I guess, clean and sober? How long have you been without drug use?
6 months.
Okay. And would you say in that last 6 months that you've been looking for a job the whole time?
Probably not the whole 6 months, but at least 4 of them.
Okay. Is there a reason why you're not able to get employment?
Transportation probably would be one of the biggest ones, but.
Okay. Do you have a driver's license?
No.
Why do you not have a driver's license?
It was suspended a while back. I actually, I have to, because after like, I think it's 4 years of having a suspended license, you have to like do all the testing all over again. And I've taken the test at Secretary of State. I just have to take the road test. So as soon as I do that, I'll have my license reinstated.
Okay, when do you expect to do that?
Soon.
Like within the next month? If you're released today, would you be able to do it next month? Okay.
Yes. Yeah.
And could you have your driver's license within the next 45 to 60 days?
Yeah, for sure.
Okay, so are you able to make any payment towards your support obligation now, or when would be the first you could make a payment?
Like I said, I can make a $300 payment as soon as I can be released, and then I can make another one the following Friday, which I think you said was the 29th.
Okay, so you would not be able to make any payment at all unless you're released?
I don't know. I think I got like a little under $100 in my account here right now. I mean, and you guys are more than welcome to it if that's what, you know.
Okay, so you could pay that $100 today and then pay another $300 as soon as you're released, like the day you're released?
Yes.
And then another $300 by next Friday, the 29th?
Yes.
Yeah. Okay, thank you. I have no further questions. Thanks.
Okay. Ms. Krouse, you stated that a lot of things that you could do. Well, I could get my license in the next 45 days. Yes, I could get this employment, but you haven't done it now, and other than the last month, you hadn't done it for 11 months before that. Why didn't you do it 11 months before that?
Like I said, I have a history of drug use, and I was screwing up, and I will admit to that and take responsibility for that. Okay, but you said that you'd been clean for about 6 months. So during that 6 months, you didn't have the drug issue. Why weren't you employed during that time? I don't know. I really don't have an excuse. I mean, except for the past month or so that I've been taking care of these, these elderly people.
Yeah. And let's go on that. You said that you've been working 40 plus months. So minimally, each of the for the last month, each of those weeks, you made about, at the minimum, $560 a week. And you didn't pay a cent on your support obligation. Why is that?
Well, I mean, I paid $500 the last time that I was arrested. I paid $500. I don't know if that counts towards anything or not, but
no, I'm asking you about the last month, not when you were arrested before that.
Oh, okay.
You said that you made at least $560 a week for caring for them at $14 an hour and for 40 plus hours a week. But yet in the last month, when you've been making that money, you haven't paid a cent on your support obligation. Why?
I know. I don't know. I still talk to my kids, and I give my kids money when they need it. My oldest is 17 and he's graduating this year, and he needs the help right now. And I know that doesn't count towards, anything, but it's not.
You could help him by paying the support obligation, and that money would go to whoever the custodial parent is, and they could take care of it.
Yeah.
Okay. Anything else, Ms. Huffman?
Nothing further. Thank you.
Thank you. Well, the court has heard the testimony in this matter that Ms. Krouse is well familiar with the 3 cases that she has in this matter and her support obligation. She'd previously been incarcerated for 90 days back in December of 2019 as a result of failure to comply and with the support order. So she's well aware of that. She stated that in the last month, she's worked 40 plus hours a week, making $14 an hour. So her minimal amount would have been $560 per week. That notwithstanding that, she's not made any payments toward the support obligation in this matter. She professes that, she will now start making payments, and that she is going to get her driver's license now that she hasn't got before. So she's made many claims as what she's going to do, but the court's not impressed with the fact of what she is actually, her actions and what she's done. And it's not unusual for people to profess everything under the sun when they're before the court. And yet, again, the history does not demonstrate that she intends to do that. The court will find that she's failed to exercise due diligence, failed to pay out of available resources, and therefore she is in contempt of court. With that, Ms. Huffman, anything before sentencing?
I would just ask the court to consider setting a purge amount in this case for the $300 that's I think she said she had $100 in her account right now. So if you could set a purge amount for $100 and then with a payment due by next Friday of another $300, I would ask the court to do that. Thank you.
Okay. Well, based on the history of this matter, it looks like, Ms. Krouse, that you're going to turn some things around. So the court is taking that into consideration in this matter. You've previously been, again, sentenced to 90 days. The court could sentence you to 90 days again. But I'm not going to do so. What I am going to do, however, I am going to sentence you in this matter to 60 days in jail with credit for 21 days served. The court would put a purge amount in each of your cases in the amount of, because in each of these, the first case you owe about $2,300, you owe over $8,000, then you owe about $7,500. What the court is going to do is set a purge amount in each case in the amount of $300. If you're able to do that, you wouldn't have to serve the additional time. Any questions, Ms. Huffman?
No, nothing further. Thank you.
Thank you. You're free to go. Have a good day.
Thank you, Your Honor. That's the only hearing that I have today.
Oh,
Yeah,
okay.
he's
Thank you,
here
Ms.
on
Brown.
Zoom, yes.
Have a great day.
Thank you.
Okay, so.
Mr. Sims, in this matter, you're before the court charged with contempt of court for failing to pay child support and related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand the charges, sir?
Yes, sir.
Yes,
Do you understand the charges, sir?
yes,
Okay. And in this matter, the court will advise you have a right to an attorney, Ms. Mouton.
Your Honor, I'm sorry for interrupting. However, this bench warrant hearing occurred because of an adjourned sentencing hearing that Mr. Sims did not comply with.
Okay. I wasn't aware of that. And what was Mr. Sims sentenced to?
So on November 1st, 2023, he was sentenced to 14 days with credit for 2 days, or he was to pay the $500 purge by November 10th, 2023. And Mr. Sims failed to pay the purge and he failed to report. So the bench warrant issued, and that's where we're at today. And then he paid $941 to have the bench warrant recalled.
But he didn't pay the purge amount.
No, sir.
Okay. Okay, Mr. Sims, in this matter, you've heard Ms. Mouton state that you didn't report and serve the time that you were supposed to, and you didn't pay the purge amount. Why is that, sir?
so the $900 I paid wasn't the purge amount?
You paid the purge amount was $500. You paid $941 to take care of the bench warrant as a result of your failing to comply with the sentencing. Okay, you had a purge amount to pay no later than November 10, 2023, which you didn't pay.
Oh, yeah. Well, that money I thought I brought down there I thought that was for that.
Well, you thought wrong, sir, because that wasn't when you didn't report to jail and you didn't pay a purge amount at the required time. A bench warrant was issued. You were taking care solely of the bench warrant.
Okay.
Well, what I'm going to do, sir, I'm going to give you a slightly more time, not much. What we're going to do is I'm going to order that you would report to the sheriff's department no later than 4:00 p.m. March 22nd, 2024. That's this Friday. Alternatively, if you pay the $500 purge amount prior to that time, then you would not have to serve the remaining 12 days of your sentence. You understand?
Yes.
Okay. So you either pay the $500 before 4:00 p.m. on Friday, or you end up going into jail at that time to serve your sentence.
So is I ever going to go to court for this?
Excuse me?
I said, I haven't been to court for child support yet. So I'm not going to go to court for child support, or I'm just going to keep getting spent in a circle or something.
Well, that's up to you. If you want to proceed and change your support or something, you have a right to file a petition to do so. And you can get those petitions and do it basically on your own through the circuit court clerk's office. You can do that. So, but that's up to you, but that doesn't affect us today. That's not what we're here for today.
Okay.
Okay? Anything else? You have any
No,
questions, sir?
sir.
I want to make sure it's clear to you so that you know to appear to the sheriff's department this Friday, no later than 4:00 p.m., or you pay the money. You understand?
Yeah.
Okay. Court will conclude this matter now, and you're free to go. Have a good day. Mr. Anderson, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and/or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand the charges?
Yes, sir.
Court advised you have a right to an attorney. The court would appoint an attorney to represent you should you desire an attorney. My understanding, you wish to proceed without an attorney. Is that correct?
I didn't know that I was facing no jail time, first of all. And second of all, I wanted to talk to you because I done had the kids for the last 6 years and we supposed to been on joint custody. So I don't understand why do I owe this and why. And I got the mother here with me so we can just try to figure this out.
Okay. Well, what happens is you could have the kids in your care and custody, but you have to take care of the order. There's an order that requires that you pay child support. And apparently you haven't changed that order. If you don't change the order continues, sir.
Okay. So how do I go about getting the order fixed? Because I have the kids and I've been had them and we want joint custody. The mother is right there and whatever we need to do, I need you to just guide me in what I need to do, sir.
Okay. What you're going to have to do is you're going to have to do an order modifying custody.
Okay.
So
write that down, please.
You would be modifying the custody of that particular, the order that occurred previously, whatever that order was. I don't know the date of that.
Okay.
Whatever that date is, you'd be modifying that in custody. Ms. Bouton, what the arrearages in this matter, are they owed to the payee or to the state?
They are owed to the, let me look. The majority of them are owed to the payee.
Okay. When we say majority, what are we talking?
So do you want the total arrears of today are $12,308.94. And of that, $11,471.53 are owed to Ms. Ashley.
Okay. And this is Miss Ashley that's in the video now?
Yes,
okay.
sir.
And Miss Ashley, I'm going to ask you, because obviously from what Mr. Anderson is saying, that you're willing to, forgive the arrearage. Is that correct?
Absolutely.
Okay. And you understand there's no requirement that you do that. And if you do so, you're going to do so voluntarily. Is that correct?
Yes, Your Honor.
You understand that, I'll ask you, has anybody threatened you, coerced you, used any undue influence, pressure, or promises to get you to forgive the arrearages?
No, Your Honor.
Okay. And as Mr. Anderson stated, is that your intent that, again, that you are going to modify the order that would provide for the two of you to have joint physical custody. Is that correct?
Correct. We just need to know what we need to do to file the motion or whatever it takes to get that done, sir, as soon as possible. I appreciate it.
Okay. Well, and this particular amount, ma'am, if you are waiving the arrearages today, it doesn't mean you have to waive the arrearages in the future. It's just you're waiving the arrearages of $11,471.53. You understand?
Yes, sir.
Okay. The court will, in fact, vacate and cancel that arrearage owed to Miss Ashley, as she has put on the record today that she wishes to waive that arrearage. She has acknowledged that the parties do have joint physical custody and that they're going to proceed with a modification of the, again, the custody order. So what we'll do, Mr. Anderson.
Yes, sir.
What I'm going to do is I'm going to adjourn this matter to May 22nd, 2024 at 8 o'clock a.m. That'll give you basically 2 months to get this matter taken care of. It shouldn't take you 2 months. Hopefully you'd want to get this taken care of yet this month if you could.
I'm going down there to get the forms. You said I got to get some forms?
Well, that's for a motion because Miss Ashley is willing to consent and stipulate you don't have to file a motion.
Okay.
When we talked, didn't know that Miss Ashley was there, didn't know she was agreeable. But now what you can do is you can get an order modifying your custody order. And if you there's a service you can get on, it's called MichiganLegalHelp.org.
Okay, hold on. We're trying to write it down. MichiganLegalHelp.org. Okay, thank you.
And they have all the forms on that site, and you'd want to do an order modifying custody and support effectively.
Okay.
And support. All right, cool.
And support.
And what you do in the order, they are orders that you can check the box and state in there that you're modifying the order, that you're agreeing that the parties would, have a place to fill in. You agree that you have joint physical custody. She's agreed that, again, that she would cancel the support obligation. You can't cancel the amount that's owed to the state of Michigan, or if you're on, are either of you receiving public assistance on behalf of the kids?
No, they ain't. They cut it off on me. I was
Okay.
trying to get food stamps on, but they cut it off because I had a bench warrant.
Okay, so if in fact you're not receiving public assistance, then you would be able to waive the support obligation. If there is public assistance, you cannot waive the support obligation.
Okay.
Okay, so you get on michiganlegalhelp.org, fill out the forms, get Miss Ashley yourself to sign, and then you can file them with the court. You have to get friend of the court approval.
Yes, sir.
Make sure that everything's been signed and filled out correctly. And when they give you the approval, then the court will be willing to sign that. Okay?
Okay. Yes, sir.
Ms. Mouton, you had something, I think?
Yes, Your Honor. It's two matters. First, there was a bond that was posted in the amount of $1,562. Are we continuing that bond until the next hearing?
What the court will do is they will forfeit that bond at the current time. That will take care of the balance, sir, of your arrearage. So you'll be taken care of in that regard. The balance would be above the arrearage after we take care of the, Miss Ashley's matter, that the balance would then be refunded to whoever posted the bond, okay?
Okay. All right.
And then, Your Honor, one more question. For clarification, Mr. Anderson reported to front of the court this morning that he actually has physical custody of the children. So front of the court did direct him to submit a statement saying that, so that we can abate support while they're working on getting their orders filed.
Okay, sir, if you provide that to the front of the court, they can abate the support, so you don't get an arrearage in the next month or two while we're waiting, okay?
Okay. So I got to do a abate form too, sir?
There's no form for abatement. You just basically state that you have custody and you're asking to abate the support obligation.
See, but we both want custody. I don't want it to be solely custody.
State that in your letter to front of the court then, that you want it to abate because you're both going to have physical custody, and then at least we've got something for the record.
All right, thank you.
Okay, I'm giving you the 2 months. Again, you should be able to take care of it in a month.
I'm finna get on it today. I'm finna get on today, sir.
Okay.
Today.
Okay.
All right. Thank you.
We'll let you go then, sir, and thank you, Miss Ashley, for appearing and resolving that particular issue. And we'll see you back on May 22nd.
Yes, sir.
24 at 8:00 a.m. And hopefully this is taken care of.
All right. It's gonna be back on Zoom, right?
Yeah.
Okay. All right.
Okay. Thank you, sir.
Thank you.
Have a good day.
Thank you, Your Honor. That's all I have today.
Okay, thank you. Mr. Gray, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charges?
Yes.
Court has appointed Ms. Huffman to represent you in this matter. Have you had sufficient opportunity to speak to Ms. Huffman in preparation for this proceeding?
Yes.
Ms. Huffman, are you ready to proceed?
I am, thank you.
Ms. Petrolio, you can proceed.
Thank you, Your Honor. This is the case of Shelby Pike versus Brandon Gray, docket 2020-619 DS. Mr. Gray is before the court by way of a bench warrant hearing that was adjourned from last week to allow him to be represented by court counsel. He has a minimal support obligation of $103.55 a month, $50 toward the arrearage, which would be guideline, $3.50 for fees, for a total of $157.05. I'm not sure if that 55 is correct. I will clarify that. But in any event, he did post a $300 bond that front of the court is asking me forfeited and applied to the arrearage. The bench warrant is a result of his failure to appear at an adjourned hearing on November 14th, 2023. He's had 3 prior show causes, 2 bench warrants, and 1 finding of contempt. And then last year, he should have paid a total of $1,884.60. He paid $887.26. It left him short of compliance, $997.34. And I will note for the record that amount seems, the amount that he paid is much higher because we collected the income withholding at a much higher rate than just $50. So it's not like he was paying for any extended period of time. The arrearage in this case through the month of February is $1,409.39. Again, that amount doesn't seem too high, but his obligation is only $103 a month. He doesn't owe any state owed arrearages. He did have a 21-day sentence back on July 6th of 2022 that was stayed pending him paying the purge. He did not pay the purge, so a bench warrant issued. And then in December of 2022, he contacted our office and paid $500 to resolve the bench warrant. He booked in on March 3rd. He paid the purge and got out the following day, so he has 1 day credit. He's not working. He is not paying. He comes up with money to get out to avoid jail sentences. So it appears he has the ability to come up with money, but just refuses to pay his child support.
Clarify if you could, Ms. Petrolio. You state that back in July 2022 that they stayed the matter of his 21 days, but he never paid the purge at that time. Is that correct?
That's correct. And so what happened is we got a bench warrant due to his failure to pay the purge and report to jail. So when it came time, he contacted our office to say, I have a bench warrant. What can I do to resolve it? And he paid the $500 at that point to resolve it.
Sir, you understand that when you paid the $500, that was only to take care of the bench warrant, not the prior sentence in this matter.
Yeah, I don't know. No, that's all the way from a year ago.
I don't care if it's from 2 years ago. It's still an order of the court, sir.
He said 21 days or $500.
You did not pay the purge amount.
I paid $500 cash to a sheriff.
When a bench warrant issued because you didn't pay the purge amount, then they have a bench warrant, and the bond in the bench warrant case is $500. It doesn't take care of your purge amount.
Then what's the 500 go to? That's what I was told.
The 500 would have went towards the arrearage in this particular matter, but not to satisfy the purge amount.
I'm not sure how it all works. I was just told 21 days or $500. I paid $500.
Well, you didn't pay it on time, though, sir. That's the problem. You didn't pay it on time, so they entered a bench warrant for you.
Sheriff, something at the sheriff's office at the courthouse.
Ms. Huffman, do you dispute or contest any of the statements made by Ms. Petrolio?
No, I just have some questions about.
Okay, go ahead.
Yeah, okay. So the purge amount was how much? 3 or 500?
5.
I believe it was 500.
Okay, so the purge amount was $500, and then he took care of the bench warrant with $500 for the bench warrant, but not the purge. Is that correct?
Right. Basically, he was ordered to report to the county jail or pay the purge by a certain date. He didn't do it. He didn't pay the purge and didn't report. So a bench warrant issued. So then he's like, oh, I got a bench warrant. Now I want to pay the bond. So the bond was 500, the same as what the purge was, but it was paid 5 or 6 months later.
Okay, so when you say the bond was the same as the purge, but it was the same amount, but it wasn't for the same thing?
I never even heard about a purge.
The purge becomes a bench warrant. The purge becomes a bond because he didn't report to jail like he was ordered to do. He was ordered to serve 21 days.
Okay, so does he still owe the $500 purge?
I don't know. That can be addressed by the judge.
Okay, thank you. And then the $500 bond that he did pay, was that used for arrearages?
Yes, it was basically not even a bond. It was in a bench warrant agreement letter where we said, okay, we'll take $500 to resolve this warrant. And yes, it was applied to the arrearage back in December of 2022. So,
okay, so then I would argue that was the purge amount. But either way, thank you for clearing that up.
Just for clarifications, Ms. Huffman, is an individual can't come in 5 or 6 months later after they're supposed to pay a purge amount and say, oh, now I'm going to do it and take care of it. That's not how it works.
Okay. Okay. All right. So I would like to call my client, Mr. Gray, as a witness, please.
Okay. Go ahead, Ms. Huffman.
Thank you. Mr. Gray, are you currently working?
No, I do odd jobs with my girlfriend's stepdad.
What? I'm sorry, I interrupted you.
Not at the moment because all the court dates that I have in a row, but once they spread out, I do odd jobs as of now. Just like right when this ends, I'm working paying until 1, and then I go to court.
Okay. On these odd jobs, how much do you average a month?
It just depends. Like I'm making $300. That's money. Yeah, money. Call the money.
Okay.
Okay. So you broke up on the third part of that. Did you say will make $300 today?
No, when the painting's done, we got 3 or 4 days.
Oh, when the job is done, you'll get $300?
Yes, and then rent, bills, car payment. My girlfriend has a job too, so that helps a little bit.
Okay. So you intend to find a stable job?
Yes, I already have one. It was already given to me by one of her dad's friends, but
where at?
Whispering Oaks. It's a junkyard, but you can't call in 4 times a week to go to court.
Okay, so are you going to court 4 times a week?
No, last week was 2. Today's 2. This week's 2. Next week is 1. Then the week after is 1, and then I start working.
Are they all for this case or different cases?
Different cases.
Okay. When do you expect to have all your cases resolved?
As of right.
This case or different cases?
different cases.
Okay. When do you expect to have all your cases resolved?
As of right now, the furthest court date I have out is April 5th, and that's a plea deal that I took, so that one should just be over. And then I have another one, but I just got out of jail last week, and they just handed me like 4 or 5 court dates, all day after day, pretty much.
You got out of jail when?
Like a week and a half ago. Paid $1,400 to get out of jail, and pretty much emptied our savings account.
Was any of that towards your support?
300 of it.
300 of it. Okay.
It was 500, but I tried to ask the judge because I had to be able to afford the other bonds.
Okay. So is that 300 is in addition to the other $500 that you paid for your bench warrant?
Yeah, I paid 500, 300, and then I had to pay a little bit extra to the bondsman who had to pay more. But
okay, I'm just thinking about towards this case. So you paid 300 and 500, right?
For the last one, but I paid 300 this time.
Okay.
I might not make my payment on time, but you can't make no money in jail, so I gotta be able to get out.
Hang on. Have they used the $300 that you just paid last week? Have they used that for your support?
Yes.
To clarify, I think he's talking about the bond in this matter. There was a bond of $300.
It went towards the support.
Well, it doesn't go to it until I forfeit the bond. So
are you willing to allow the court to put that $300 to? I mean, you're willing to allow that, to consent to it, right? To put that $300 towards okay. All right. So so then the court will likely do that. And then when is the next time you can make a payment?
I mean, it just depends. It could be tomorrow or next week, but I'll have a payment within a week and a half, 2 weeks, the earliest. It's just because I got a driving license thing I have to pay on, and then we got an electric bill. But after that, I'll be able to make a payment.
Okay. So do you think you can make a payment within 10 days?
Probably between like $50 and $100. Yeah, I could definitely do that.
$50 to $100 within 10 days.
Yeah. Well, Friday I got a $150 check coming, but 100 that's towards the bill. But I'll be able to put 50 on it by the end of next week, guaranteed. Okay.
All right. So the soonest you're going to be able to get a job is April 5th. Is that correct?
Well, yeah, it'll be after. I already went to the job and they wanted me to start, but I told them what was going on. They didn't want me calling in so much.
Okay. How much will you be making per hour?
It's at 14 right now, but hopefully it goes up.
And will you be working 40 hours per week? Will you be working 40 hours per week?
I'm not sure yet. They didn't give me a schedule.
Okay. Is there any reason why you haven't had a job up until now?
I had a job for all.
When did you have a job?
They were deducting money out of my check every week for child support. But
okay, and what happened with that job?
I got an OUI and they let me go. That's what the plea deal for April 5th is for. This is my OUI.
Okay, on that, so are you going to be sentenced on that day?
Mm-hmm.
Do you know what your sentence will be?
It's just probation.
Probation.
Probation, yes.
Okay, all right. I have no further questions. Thank you.
Okay. Mr. Gray, in this matter, let's say in the last year, other than the odd jobs, if you say, in the last year, what jobs, full-time jobs have you worked?
I worked at Sheriff Gosselin last year all the way until May, until I got an OUI.
Okay. Obviously, during the time, how long did you work at Sheriff Gosselin?
About a year and a half.
Well, based upon the arrearage in this matter, you have an arrearage in excess of $1,400, and you're only paying about $150 per month. So when you worked at Sheriff Gosselin for a year and a half, you weren't paying any support during that time. Why?
I mean, according to my bank stuff, it was getting taken right out of my paychecks.
When you were asked about the odd jobs, you said you make about $300. Is that on average per month?
It just depends. The jobs come and go.
Okay.
I mean, that's just temporary because of all these court cases.
Okay. What's your education background, sir?
I got some high schooling.
Did you graduate?
No.
How far did you go?
10th grade.
Have you sought out your GED to complete that?
I did the first 2 tests, but I never finished it. It's a work in progress. My girlfriend's just talking about that.
When was the last time you took any classes for your GED?
I mean, it's been a while. Got a busy life. That's a lot going on.
Well, don't you think that would help you to get employment if you, again, completed and had a high school diploma?
Probably.
Anything else you'd like me to be aware of, sir?
I mean, other than the job coming up that I'm getting, not really.
Okay. Ms. Pike, is there anything you'd like me to be aware of?
This is not my turn.
Yes, Your Honor, I have, my last child support payment was last year of $50. He is in and out of jail for drug charges and nothing for any kind of support. Aubrey is home Monday through Sunday, 7 days a week, and I'm not getting any type of help. He doesn't get any visitation. I do have full custody of her right now, until the judge recommends some kind of rehab.
Anything else, ma'am?
I'm sorry about that. My daughter was doing something. So like I said, he's in and out of jail he has money to support drugs and bond money, but he never has money to support every month for the child. And it's the only time the amount of money comes is when he's bonding out of jail, as the record would show that that's the only time that he really pays. So I'm recommending something happening because right now I'm not getting any kind of help with her.
Okay. Thank you, ma'am.
Thank you.
Anything else, Ms. Huffman?
So I would just ask the court to consider that he was just in custody last week, is my understanding, and then he did just pay a $300 bond. So I would ask the court to take that into consideration when making a finding. Thank you.
Thank you. Well, Ms. Huffman, at least he was in jail, but not for this matter last week. It was for the other matter. So he's not getting credit for a time that he wasn't in on
He was
this.
in jail yesterday for arson. Yeah.
Well, the court's heard the testimony in this matter that Mr. Gray has stated that, again, he's well aware of the support obligation as he has been incarcerated previously, that there was a 21-day jail sentence back on July 6, 2022, and we've already went through that particular matter, that he was picked up on his other case and it was held, so he has credit for 1 day served on this particular matter, that he stated he's not working, he works odd jobs, makes approximately $300 per month. He has in the past. However, he has not paid towards the support obligation in this matter, which is minimal, just $150 some per month. And he's not paid consistently in this particular case. He's paid when he obviously has a bond or a bench warrant or something else, but not on the support obligation, other than, again, incidentally to, again, get himself out of jail. He stated that he was employed by Sheriff Goslin up through May of 2023. He'd been employed there for a year and a half. Lost that job when he had a drunk driving offense. However, it doesn't appear, based upon the amount of arrearage, that, again, that he was paying consistently at that particular time. And he hasn't, since the Sheriff Goslin, he hasn't paid, even though he's had the $300 per month, he hasn't been paying on his support obligation. Court will find that he's failed to pay out of available resources, failed or refused to comply in this matter, and therefore the court will hold him to be in contempt of court. Anything for sentencing, Ms. Huffman?
I would just ask the court to, if the court's going to require that he serve that 21 days with 1 day credit, I would ask for a purge amount to be set in the amount of the $50 to $100 that he indicated he could pay within the next week. Thank you.
Okay, thank you. Well, sir, what happens is I'm not limited to the 21 days that you'd previously been ordered to serve. I could have you serve up to 90 days in jail. What? I'm not going to sentence you to that much time in this matter, but I'm going to sentence you to an amount that would impress upon you. You have to take care of this particular matter. What I'm going to do, first of all, I'm going to forfeit the bond previously posted. The court's going to sentence you to 45 days in jail with credit for 1 day served. What I'm going to do, because thankfully your arrearages are a smaller amount, what I'm going to do is I'm going to send you to jail, require that you report to the sheriff's department.
There ain't no money I can pay, bro. You just finna send me straight to 45 days in jail.
Yep, I'm gonna get to that.
All right.
I'm not done, sir. Court is gonna order that you report to the sheriff no later than 4:00 PM on March 29, 2024. No. We lost Mr. Gray.
He might have hung up.
Well, we'll give him a time a few minutes to rejoin.
You want me to try to call him, Your Honor?
Yeah, if you would, Ms. Petrolia, I would appreciate that.
See if I can- All right. I told him hopefully he'll zoom right in.
Okay.
We're waiting for him.
Okay, Mr. Gray, I was concluding on state that you have to serve that time. You have to report to the sheriff no later than March 29, 2024. That gives you about a week and a half. What the court's going to do is the court is going to, because of the forfeiture of the bond, what the court is going to do is I'm putting a minimum. I'm going to have you put your purge amount in the amount of $200. If you're able to post the purge amount, then you wouldn't serve the time in jail. You understand?
Yes.
Okay. But I want to be clear, if in fact you do not pay the purge amount by the March 29th date or go to jail, that in this particular matter, you're going to end up serving the balance of your 44 days. You understand?
And the warrant goes out tomorrow?
What?
So it'll be a warrant until the day I pay it.
There's no warrant now.
Okay.
Okay. But if you don't do this by March 29th, 2024, there will be a bench warrant out for you.
So I'll just pay $200 to the child support office?
Yes.
Okay.
Okay?
Yeah.
That will conclude the matter, and you're free to go. Have a good day.
Hello?
Hi, yes, it
Let's
is.
go into our- Okay, one moment, please.
Okay.
And Heather, you said that the custodial parent was joining for this?
Yes.
I'm sorry, what?
That's what she told me. Nina Trim.
Let me see, I do have a Nina here, let me get her.
I think she's on too.
Okay.
Hi. I'm not muted, am I?
No.
Okay.
Okay. Ms. Trim, can you hear us?
Yes.
Okay. Ms. Trim, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charges?
Oh, 6,000.
Okay, whoever has something on in the background, please shut it off. Ms. Trim, in this matter, the court has appointed Ms. Huffman to represent you in this case. Have you had sufficient opportunity to speak to Ms. Huffman in preparation for this hearing?
Jessica, he's talking to you. Have you had time
Oh,
to
I'm sorry.
speak to me? Yeah, that's okay.
I spoke with her right before. She tried to get me a dial-in number because the video and stuff wasn't working.
Okay. My question is, did you have sufficient opportunity to speak to Ms. Huffman to prepare for this case?
Yes.
Okay. And Ms. Huffman, are you ready to proceed?
I am, thank you.
Ms. Petrolio, you can proceed.
Thank you, Your Honor. Ms. Trim is before the court today by way of an adjourned hearing to monitor compliance with LEAP. She has a current support obligation of $204 a month. She has to pay the arrearages pursuant to guideline at $50 plus fees for a total of $257.50. Her last payment paid was $125 on November 21st of 2022, and that was to resolve a bench warrant. She has had 5 prior show causes, 2 bench warrants, as well as a contempt finding. In the last 2 months, she should have paid a total of $515. She's paid nothing. The arrears on this case is $2,884.34, and that's through the month of February. I would not ask that she be allowed to go back to LEAP. She's failed numerous times with excuses every single time. She hasn't paid since 2022. She did have a contempt finding that was in June of 2017, and she was sentenced to 45 days in the county jail, and it was suspended compliance with compliance of the support enforcement order. So
What was the year of that sentence?
June of 2017.
Okay, thank you.
Yeah.
Ms. Huffman, do you dispute or contest any statements made by Ms. Petrillo?
I do not. I just have a few questions.
Okay, go ahead.
Did Ms. Trim pay from 2017? You indicated she had to have full compliance. Did she pay from 2017 to 2022 regularly at that time?
I was modified to 0 at some point.
I can say she paid much more regular than she is now. I mean, it's been a year and a half at least since she's made any payments on the case. So yeah, it looks like especially in 2021, she paid fairly consistent up until June.
Okay, thank you. The support order was modified, looks like November 2nd of 2023. What was that, increased or decreased at that time?
Increased.
Was it based on actual or imputed income?
I don't know offhand.
Okay, that's fine. Do you know why it was increased? Was it just a regular 3-year check support review?
If you want me to look, I can see if I can figure that out. I don't have that information available, but I can look if you'd like me to.
Well, I was just kind of getting to the point, trying to make the point of maybe it's time for her to look into amending the support obligation again, but it was just done. So if it was done with the amount of money she's actually making versus imputed, but I'll let her, you don't have to look, I'll let her make the decision whether she wants to.
Okay, I found something. It looks like there was an unordered change in custody. So a review was done. Minor child Lillian was with Nina Trim and Kaylin was with Colby Mann. So she's paying both parties under the same docket.
Oh, I see. So it's split between Colby and Nina or Nina?
Yes.
Okay, thank you. I have no further questions.
Okay. I'll ask, don't mean any disrespect to Ms. Trim, but I'm going to refer to you as Jessica because we'll get confusion with Nina Trim. So Jessica, this matter, when was the last time that you worked?
At Schlotsky's, and it wasn't long because me and my kids were living in a hotel for a year and just got out of a hotel. But I can make a payment today too.
Okay. When was the last time that you worked? Approximately. You don't have to have the exact date.
Like, hold on. Like last fall?
Fall of 2023?
Yes.
And where did you work then?
At Schlotsky's.
Okay. And you said you didn't work there very long?
No.
How long?
I think like 2 weeks.
Well, why did you only work 2 weeks?
My kids kept getting in trouble at school and I kept having to get them. And I didn't have anybody.
Before Schlotsky's, where did you work?
I didn't.
Okay. You didn't work. You never worked before Schlotsky's?
I did, but I just can't remember where.
Okay. How long was it before Schlotsky's that you last worked?
I think like 6 or 7 months.
How much?
6 or 7 months, I think.
Yeah. And where did you work at that time?
Goodwill, I believe.
And how long would you work at Tidwell?
I don't remember.
Okay, are we talking a week or are we talking 6 months?
Maybe a week.
And why did you leave after a week?
Babysitter issues.
And before Tidwell, where did you work?
I did not, because I think I tried to apply for disability. There's a bunch of different gaps. Like I can't remember every single place. I know I've worked in a few factories, but that's been a couple years.
Okay. Let me ask you, in the last 6 months, other than the job at Schlotsky's, the last 6 months, what have you done to acquire employment?
Well, I mean, I I haven't. Like, I was going to leap for a second, and then after that, 2 months ago, my husband died, and then I've been dealing with things with my kids, the 5 kids that live with me, so I haven't really been working or looking for work right now. Because I've been dealing with everything else.
Ma'am, what's your education background?
I got a diploma from Christian Cornerstone.
Okay. Well, what can you tell me? What's going to change next week over this week so the court has any confidence that you're going to be able to pay your support obligation?
Well, I was gonna ask about, like, when that lady said that it was a split one, like, can I get it lowered some?
You can always file a petition to have your support obligation reviewed and modified, but you're going to have to do that. You have to go to the circuit court clerk's office and fill out the paperwork to have a review done, but that's going to be up to you to do that, ma'am.
Okay.
And you can do that anytime.
So what's the lowest payment that I would be able to make on it?
I have no idea. What you're going to have to do is you're going to have to file the motion, and then at that time there'll be a hearing, and they'll take into consideration all sorts of things to determine what you
Those are my favorites.
what you could pay and what the what you could earn, et cetera. So there's a lot of things that have to be considered at that time.
Okay.
Well,
I talked.
What, Ms. Huffman?
May I ask a few questions?
Sure, go ahead.
Thank you. Jessica, you said you'd be able to make a payment today. Is that the $150 payment you could make today?
Yes.
Okay. And then you also told me that you could make another $100 payment by April 10th. And then starting May 1st, you believe you could start making your obligation of $257.50. Is that right?
But I'm sorry, can you repeat? Did you say May 1st?
Yes. So that would give you like a little over a month to get your job secure and start working and get payment so that you could May 1st start making your regular monthly payment.
Well, yeah, and then by then I was hoping to get the modification that he was talking about.
Right. So in between, and you can file a petition. You have to actually file the paperwork yourself. Okay. You understand that?
Yes.
Okay. So file that and see where you can get with that. But in the meantime, you can make $150 payment today, $100 by April 10th, and then May 1st, start your regular monthly payment of $257.50. Is that right?
Yes.
Okay. You indicated you have 5 children that live with you. How old are the children that live with you?
Correct. I have a 10-year-old. I have a 9-year-old, a 7-year-old, a 5-year-old, she's going to be 6, and then a 2-year-old.
Okay. So all but one are in school. Is that correct?
Yes.
Okay. So you won't have the daycare issues, hopefully, and you'll be able to work, right?
Right. I've just been having to go to my kids' school and do safety plans and other things because my kids have been going through something lately. So they've been getting in trouble.
Okay. So, and then you also indicated that your husband just passed away. Is he the father of those children?
No.
Okay. Do you get support
for the youngest?
Okay. Do you get support for those children?
Well, I have, yes, Riley and Adeline.
You get child support for those 2 of them?
Yes, those are Colby's kids.
Oh, okay. And then you're going to get some type of benefit payment from the death of your husband for the youngest child. Is that correct?
That's what I'm in the process right now, trying to get is the survivor benefits for her.
Okay. So there's some things coming up that are going to be changing for you, and you expect to be getting some income, right?
Yes.
Okay. I don't believe I have any other questions. Thank you.
Jessica, you stated in response to your attorney that starting May 1, you can start making the monthly payments. How are you going to do that?
Well, because I was like I said, I was hoping to get them modified. Like,
what if you don't get it modified before May 1? Then you wouldn't be able to make your payments. Isn't that correct?
Correct.
So I don't have a problem with you making the payments starting May 1, but that's going to require, as we stated, that requires something on your behalf to to file the petition to have it all done and accomplished by May 1. Ms. Petrolia, you had something?
Yeah, I kind of want this addressed because while Jessica didn't tell me this, Nina did, that she apparently is pregnant now with a high-risk pregnancy. So I don't know how she's going to go out and look for work if she's got a high-risk pregnancy.
Well, maybe you can answer that, Jessica. How's that going to happen?
Because I still, like, I could still do certain things. But right now I've just been dealing with my kids, my husband, my move. A lot of stuff has happened. Like, and I have full sole custody of 2 of the kids that live with me. Well, and then my youngest, her dad just died. So, like, I can start making payments.
Okay. Anything else, Ms. Huffman?
Nothing further. Thank you.
Okay. So, well, the court's heard the testimony this way. I guess I'll ask Nina Trim, do you have anything to add or say?
No.
Okay.
Other than she has an autistic child.
Okay. Well, the court has heard the testimony in this matter that, again, she has supported rearage just under $3,000. That, in fact, she has stated a lot of things that she can do, she's going to do. They all, quite frankly, appear to be pie in the sky based upon her current circumstances in this matter. It's not really a legitimate plan when you say, well, I'm going to do this, and I am going to do this, and I should be able to do this, when, again, the history has not shown that she's been able to do any of that stuff in this particular case. That the times that she's worked has been for a minimal period of time, that she hasn't paid regularly and consistently since back in 2021. So we're now going on 3 years that she hasn't paid consistently. That the last job she had in fall of 2023 was for 2 weeks. And the time before that was she only worked a week. So the court's not, impressed with, again, the diligence in getting these matters resolved. Court will note that she has previously had a 45-day jail sentence back in 2017. And that as a result, obviously, she's clearly aware that she has a support obligation in this matter, that she's obviously aware of what she has to pay, that she has failed or refused to pay, and she's not exercised due diligence to do so. And when she had the resources, although they were limited at that time, she did not pay out of available resources as well. As a result, the court will find that she is in contempt of court. Anything, Ms. Huffman, before sentencing?
Yeah, so if the court intends to sentence her to jail time, I would ask the court to set the purge amount at $150, which she indicated she can pay today, and then with another payment due by April 10th of $100. Thank you.
Okay. Well, what the court is going to do in this matter, Jessica's court notes that I could sentence up to 90 days in jail. I'm not going to do that because that's a substantial amount of time. But what I'm going to do is I am going to sentence you to 45 days in jail with credit for no time served. The court will allow you to purge yourself of contempt by paying the sum of $150 today. In fact, I'll give you actually until this Friday, March 22nd, and also require that you pay an additional purge amount of $100. So it's a purge amount of $250. You pay the $150 by this Friday, then you pay the $100 by April 10th, 2024. If in fact you fail to do so, then you will report to the sheriff no later than 4:00 p.m. on April 12, 2024 to serve your 45-day sentence. You understand that?
I don't actually, and I want to make sure that I understand.
Okay.
So
I'm ordering a 45-day jail sentence, but the purge amount, I'm giving you 2 dates to pay. The $150 purge amount you pay no later than this Friday, March 22nd, 2024. Then you pay the second part of the purge amount. It's a $250 purge, $150 this Friday, $100 on April 10, 2022. If you fail to pay those particular purge amounts on those dates, then you will report to the sheriff on April 12, 2024 to serve your 45 days in jail.
Is that by 4 p.m., Your Honor?
Excuse me?
Is that by 4 p.m.?
Yes.
Okay.
Yeah. 4 p.m. on the April 12th date. So,
Jessica, do you understand you have to make a $150 payment by Friday and then another $100 by April 10th? If you do that, you do not have to go to jail. If you don't meet both of those dates and payments on both of those dates, you're going to have to go to jail at 4 p.m. on the 12th of April. Okay.
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 Now I get it.
Okay, thank you. That will be the order of the court. You're free to go. Have a good day.
Thank you. Yes.
Do you have a phone number?
Mr. Hawkins, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand the charges?
Yes.
Okay. And in this matter, the court will inform you have a right to an attorney if, in fact, you wanted to have that attorney. The court would, in fact, provide you and allow you to have the attorney. You understand that?
Yes.
And it's my understanding you wish to proceed without an attorney. Is that correct?
Correct.
Are you doing so freely and voluntarily?
Yes.
Has anyone threatened you, coerced you, used any undue influence, pressure, or promises to get you to appear without an attorney?
No.
Mr. Hawkins is before the court by way of a bench warrant after he failed to appear for an adjourned hearing on October 17, 2022. He has a current support obligation of $69 a month. The arrearages pursuant to guideline would be $34.50 plus fees for a total monthly obligation of $107. His last payment that he paid on this case was $20 on August 18th, 2022. He did post a bond of $500. He booked into the county jail on March 1st and left the county jail the same day. So I would say time for no days, since he didn't serve a full day. He has had 2 prior show causes. This is his 3rd bench warrant. There has been a finding of contempt. In the last year, he should have paid $1,284. He's paid nothing. The arrearage is $2,362.10 through the month of February. He did have a 30-day jail sentence back on December 5th, 2018 that was stayed to allow him to participate in the delayed sentencing program. He didn't comply with that, and I think probably a bench warrant issued back then. But this failure to appear is due to an adjourned hearing that he failed to appear for on October 17th of 22. He is not currently working, by the way.
Okay. Mr. Hawkins, do you dispute or contest any of the statements made by Ms. Petrulio?
Contest?
Yeah, or anything that she just said that you believe is inaccurate?
I mean, I know for sure that my arrearages was higher than $2,000. It got lowered. I did pay a decent amount on that. I believe, if I'm not mistaken, I believe it got lowered. But I want to build a foundation on what I want to say to, I don't know, like because I feel like I'm not heard. I don't voice myself enough in court, and I want to voice myself right now and try to get you to understand where I'm coming from. If that makes sense.
Why don't you just tell me what you want to tell me rather than going into this gyration, because you're setting the stage for this. Doesn't do anything for me.
Okay, well, I know I'm on child support. I know I got to pay. That's very clear. I know I haven't been paying. That's very clear. My thing is, when my daughter, I take care of her. When she comes over, when she's in my possession, she don't need for nothing. She don't need for nothing. She can go to school. She eats. She's clean clothes, everything. I'm missing birthdays, Christmases, Thanksgiving, holidays, so many things. She moved her to Maryland without me knowing. She moved her to Maryland and didn't inform me. And I had no idea about that. She moved her back to Michigan, didn't tell me. I had no idea about that. I don't even know what school she's attending. I don't know when the last time she had a doctor's appointment. Like these things I should know, because if I'm paying child support, or if I'm supposed to be paying child support, I feel like I should know these things, and I don't know these things. And she's very well taken care of. It's not like I'm out here just out here on drugs or anything of that nature. She's very well taken care of. She can be educated and everything that a kid is supposed to do. She's 9 years old. So I'm just trying to figure out, is it a way for me to maybe see about the child support being ended somehow, or I give up my rights or something, because I feel like it's unfair, because I do my part as a father. I'm sorry not to gyrate, but I even got pulled over before, and the officer's just like, yeah, you got a warrant for child support. I'm like, yeah, my daughter's right there. They see her. They're like, dang, how many kids do you got? Long story short, I take care of my daughter regardless if I'm not giving you guys the money or, that sort of ordeal. But I just want to figure out, how can I do better or try to get this whole child support thing minimized, because I take care of her. Okay. I had her from July to September 2023. Had her for 3 months.
Okay, well, I'll tell you, sir, first of all, what we're here today on is the issue of child support. So all those other issues, you have a right to file a motion seeking intervention, if you would, from the court, or getting modification but that's separate from today's hearing. That has nothing to do with today. What you're going to have to do is you're going to have to go to the circuit court clerk's office and
Okay.
get a pro per motion packet, and then you file a motion stating whatever it is that you want. Okay?
I'm sorry. What can I write that down real quick? I'm sorry. You said it was a pro what?
Pro per, meaning yourself, you're there, a
Okay.
motion. And the motion would be, I don't know if you want to change custody, pay parenting time, get information. A motion is just a request to the court, and you can ask for anything that you're legally entitled to, but you're going to have to do that separately. That doesn't have anything to do with your support obligation.
Okay. And I'm sorry. I never asked or I never voiced myself. So that's why I just want to know that information.
Nope, you have all that. If she moves the child out of state without court approval, then you have a right to file to have her held in contempt of court for doing
Yes,
that.
yes.
That's up to you. You've got to file it. The court doesn't initiate it because, as you can imagine, we have tens of thousands of cases, and we don't know what's going on in those cases.
Yeah.
So that's up to you. It's up to you to bring it to the attention of the court. If you do, the court will address it at that time.
Okay.
So,
Will do.
in this matter, tell me, why have you not paid any support since August of 2022?
I mean, kind of going back to what I said, I besides me not paying, I have her. I just like I be having her, and I don't have a car. That's the number one thing that I told the enforcement officer. I don't have a car. That's the biggest problem right now. I don't have a job, so money's
Okay,
tight.
why don't you have a job?
Because I don't have reliable transportation. I don't.
Well, there are places. Could you find a job close to where you live, or take public transportation, or something like that?
I'm sorry. As of right now, yes, I've been looking for jobs in walking distance. So I don't have to worry about transportation. But as of right now, it's just I'm job searching and I'm doing my best.
Okay. In the last 6 months, how many jobs have you applied for?
I say about probably like over 10. Plenty of jobs. I don't have that much of work history, so a lot of jobs haven't, like they'll hold me off and put me on the shelf until they feel like they can call me because of my work history isn't so well.
When was the last time you worked?
Last time I worked, I believe I was working at Hilex out in the fort. I believe 2022. 2020, I was working at Subway 2021. I believe I started working January 1st at Hilex 2022, and they ended that assignment, so I haven't had a job since then.
Are you registered with any employment agencies?
Express Employment, don't let me lie. I don't want to lie to you. EPI, I believe. I know they get mixed up. It's WSI and EPI. Manpower. I just applied for Magna. I have a brother that works out there, and Denzo as well. And that was recently in the past month. I just did those.
And do you know why you have not gotten a job?
Me, like I was saying, me personally, history, because I don't have that much of work history, and it's a year gap between my work history. They don't really want me, or like they it's not like they don't want me. They put me on the shelf and just have me on call for when a position do open up for someone like me.
How have you supported yourself in the last year if you not have any income?
I babysit for my sisters. I got 2 sisters with over 2 kids. I babysit for them, and they pay me side money on the side.
How much do you make on a given month babysitting?
On a month babysitting, I say about $400.
Okay. And that's during this entire time when you haven't been paying any support.
Yeah, but
okay.
in between that, I'm sorry not to cut you off, Your Honor, but in between that time, I have had my child. I have taken care of her.
Okay.
It wasn't like I just had the money and was just gambling it away, nothing like that. She was a part of that money as well. It wasn't like it was just gone, like just being spent.
Well, and that will be the subject of another motion that you file, but I'm not addressing that today.
Okay. Yeah, it's just I don't know.
What's your education background, sir?
I dropped out in 11th grade, so high school.
What grade?
11th.
Have you sought your GED?
No, I know it's a few programs, I believe, at across the street from the library that I heard a few times. I never applied for it, honestly.
Why is that?
I'm not gonna lie to you. I never did it. I never took the time out my day to go do it.
Okay. Well, sounds like you got a lot of days with a lot of time that you could do it. So
yeah, it's
okay.
It's time for me to.
Anything else that you'd like me to be aware of, sir?
I'm sorry. Just let me brainstorm a little bit. What else I was supposed to bring up to your attention? No, I think that's it. I do got to
Okay.
follow those motions.
Okay. Well, in this case, court make the following finding that Mr. Hawkins does have a minimal support obligation in this case, approximately $107 per month. So he doesn't have a substantial amount. As he stated, he hasn't worked since back in 2022. Other than currently, he is working babysitting for his sisters, where he's making $400 per month, and he has, in fact, the entire time of the last year up through the current time. So the court will find that he has had available resources in which to pay his support obligation, because it is a nominal amount at $107 that he's failed or refused to comply. He's well aware of the support obligation that he has, obviously having previously been held in contempt back in 2018, where he had basically had 30 days in jail. And he's not, what?
I'm sorry. I'm not going to say I never, but I wasn't too clear on how much I was supposed to pay every month. The last time I spoke with the judge was a while ago, and
well, all you have to do, sir, is check the circuit court clerk's office, and you can look at your file, and in your file there's an order for support obligation, so you don't have to rely upon your memory. You can get that from the clerk's office anytime you want.
Okay, I didn't have that information. I didn't know I could do that.
Yep. Court will note that again that Mr. Hawkins has stated that he has applied in the last 6 months. He's put in about 10 applications. I will tell you, sir, you can put in 10 applications in one day if you are diligently seeking to get employment. So the court's not impressed with your effort in that regard. Court will find that you, again, fail or refuse to pay out available resources and fail or refuse to make reasonable attempts at compliance, and therefore you are in contempt of court. Is there anything you'd like to say before sentencing, sir?
No, sir.
Okay. Well, you had previously received 30-day jail sentence that you didn't serve. I could sentence you up to 90 days in jail. I'm not going to do it that much. What I'm going to do is I am going to sentence you again to 30 days in jail. I am going to give you credit for 1 day served. You were not in jail the entire day, but you should get credit for the time you were there. So you get credit for 1 day served. The court will order that you report to the sheriff no later than March 29, 2024 at 4:00 p.m. Or in the alternative, you can pay a purge amount of $500. So you show up to the jail on March 29, 2024 at 4:00 p.m. or you have $500 paid before that time. You understand?
Yeah. So so before that time, I just got to bring 500, and I'll be.
Yep, $500 paid at the front of the court's office before the March 29, and then you won't have to serve the jail time.
Okay, I can.
Yeah.
Is the bond of 500 that he posted forfeited?
The bond is, yeah, thank you, Ms. Patricia. Yeah, the bond is forfeited, but you have to pay another 500 before that date.
I'm sorry. Can I ask why is it forfeited? Because I walked to the courthouse. I didn't know that it was a Zoom call. I was there.
Well, again, I'm not going to address that. That's again not before me either. The bond you posted is forfeited. So again, that has nothing to do with today's proceeding, because today's proceeding is whether you were in contempt, which the court has held you in contempt of. So you pay between now and the 29th, you pay $500 if you want to stay out of jail.
I would ask, to Your Honor, that all future hearings be scheduled in front of the assigned judge hearing hearings.
That's fine. The court will have future hearings before the court.
Thank you, Your Honor.
Okay.
Your Honor?
Yeah.
Is it a way I can switch my enforcement officer as well?
No, unless there's a basis, you'd have to go through the front of the court for that.
And what is a base issue?
I'm saying if there's a basis, if you have a basis, you'd have to go through and file something with the front of the court to seek to have a change.
Okay.
I'm not going to give you a litany of that so that you can then say these are the reasons. If you have a legitimate reason, then you file with the front of the court and they will make a determination whether that's appropriate.
Okay.
Okay?
Yep.
Thank you. You're free to go. Have a good day.
You too.
Tiffany Broman versus Adam Broman.
That's all I have today.
Good afternoon to everyone. Court will note that this is the time and place set for the revocation of paternity hearing in this matter filed by the defendant. I guess I'll ask Mr. Broman, are you ready to proceed?
Yes, Your Honor.
And Ms. Broman, are you ready to proceed?
Yes, Your Honor.
And Mr. Magnuson, the court will note your appearance on behalf of the front of the court. Are you ready to proceed?
Yes, Your Honor.
Okay. Mr. Broman, do you wish to make an opening statement or simply proceed to proofs?
We can simply proceed.
Okay. Ms. Broman, do you wish to make an opening statement, or you can reserve your opening statement, or you can waive your opening statement?
I'll waive my opening statement.
Okay, thank you. Mr. Magnuson, do you have anything to say?
No, Your Honor.
Okay.
Sir, you were married to Ms. Roman on August 23rd of 2015, is that correct?
That's correct.
And the child Tate was born during the marriage. Is that correct?
Yes,
And you and she are still technically married. Is that correct?
technically correct.
Okay. Nobody's filed a complaint for divorce, or there's no divorce proceeding in place. Is that correct?
Not yet. We had started the proceedings years ago, but we still have to follow through with it.
Okay. At the time of Tate's conception, were you and Ms. Roman living separately and apart?
Separately, yes.
Okay. Any possibility in your mind, and I know we have further evidence that's come to fruition, but any possibility in your mind based on the facts that you could be the father of this child?
Zero possibility.
Okay. And you brought this motion seeking to essentially disestablish yourself as the legal father of the child?
Correct.
Okay. And you and Tate have no relationship or anything like that?
No.
Thank you. I have nothing further.
Okay, thank you. Ms. Froman, do you have any questions of defendant?
I do not.
Okay, thank you. Just to confirm, Mr. Vroman, I know Mr. Magnuson was being very delicate in his questioning of you, and unfortunately I have to be more direct in this matter. When you stated that at the time of conception you were separated, at the time of conception, had you and did you engage in any sexual relations with the plaintiff?
No, Your Honor.
And if you recall, when was the last date that you recall that you had sexual relations with the plaintiff?
It's been greater than 5 years ago.
Okay, thank you. With that, Mr. Magnuson, do you have any additional questions as a result of the court's questioning?
No, Your Honor.
Okay. Ms. Vroman, do you have any questions?
No, Your Honor.
Okay, thank you. Okay, Mr. Magnuson, do you wish to inquire of Ms. Vroman in this matter?
Yes, Your Honor.
Okay. Go ahead, Ms. Magnuson, whenever you're ready.
Ma'am, you are the mother of Tate,
Correct.
Yes.
and Tate was conceived and born during your marriage to Mr. Vroman. Is that correct?
Yes.
And you heard the court's questioning of Mr. Vroman as to the timeline of your sexual activity with him. Did you hear that?
Yes, I did.
And was his answer correct? Would you agree with what he indicated?
Yes, about 2017.
Okay. Any possibility in your mind that he could be the father of the child?
No.
And he doesn't maintain a relationship or hasn't maintained a relationship with Tate, is that correct?
Right. No, sir.
Okay. And there is no divorce pending, or there's been no divorce filed in this case, be correct?
Correct.
Who is the father of Tate?
Austin Lesher.
Are you willing to cooperate with our office if necessary to establish paternity of Austin Lesher as Tate's father?
Yes, we were waiting for these court documents to apply for Social Security and birth certificate.
Thank you. I have nothing further, Your Honor.
Okay, thank you. Any additional witnesses that you have, Mr. Vroman, or not?
Nope.
Ms. Vroman, do you have any witnesses?
No, Your Honor.
Okay. Mr. Vroman, do you wish to make a closing argument?
No, Your Honor.
Ms. Vroman?
No, Your Honor.
Okay. Mr. Magnuson? Well, probably, Mr. Magnuson, we should just get the DNA report admitted.
I would, yes, Your Honor, I would move for the admission of the, I believe it's dated January 2nd of 2024. It's the genetic test report.
Okay. Mr. Vroman, do you have any objection to the admission of that DNA report?
No objection, Your Honor.
Ms. Vroman, do you?
No.
Okay. Court will admit the DNA report dated January 2nd, 2024, showing a 0% probability of paternity, signed by William Sun, PhD, Lab Director of DNA Diagnostic Center. With that, you have any argument or anything, Mr. Magnuson?
Just, Your Honor, I believe that the court's been provided with clear and convincing evidence that Mr. Vroman is not the father of this child, could not possibly be the father of this child, and I would ask the court to so find.
Okay, thank you. Well, the court has heard the testimony in this matter. It's clear that the child in this matter was in fact conceived during the marriage. However, based upon the testimony of both parties, in this case, Mr. Vroman testified that the last sexual activity he had with the plaintiff was 5 years ago. She testified that the last would have been in 2017, and that both of the parties testified that the defendant did not engage in or have any relationship with Tate whatsoever. In this matter, the court has notes that we have admitted the DNA test report of January 2nd, 2024, which shows a 0% probability of paternity in this matter. As a result, the court is firmly and clearly convinced that, in fact, the defendant is not the biological father in this matter. And as a result, the court will enter an order determining the child was born out of wedlock and not issue of this marriage. With that, Mr. Vroman, is there anything else?
No, Your Honor.
Ms. Vroman?
No, Your Honor.
Okay, Mr. Magnuson?
Nothing further, Your Honor.
Okay, thank you. I'll tell the parties if you wish. Court will take care of this order once we complete the case here today. And if you wish to have copies of the order, you can go to the circuit court clerk's office and get a certified copy, which you'll probably need, Ms. Vroman, as you proceed, as you stated you were going to. Okay. Okay. Thank you. You're free to go. Have a good day.
You as well.
Thank you, Your Honor.